Hey folks, welcome back to the channel. Today's custody case dives into a messy mix of accusations, excuses, and jaw-dropping parenting decisions. The mother claims the father has alienated her from her children, but her own actions tell a different story, from skipping school events to showing blatant favoritism. Meanwhile, the father came prepared with receipts, literally proving he's been the consistent parent through it all. Let's watch as the court sifts through this mess and decides what's best for the children.
Good morning.
Can everybody hear us?
Yes.
Yes.
Sure. Okay. Thank you, everybody, for your patience. Okay, so this is case number 2017-3386 DM. Aaron Owen, formerly known as Frazier versus Stephen Frazier. It is Thursday, January 2nd, 2025 at 8:40 a.m.
Court will note the appearance of Ms. Reed on behalf of the defendant. This matter is before the court on the for an evidentiary hearing and defendant's motion to modify custody, parenting time, and support in this matter. Are you ready to proceed, Ms. Reed?
I'm ready to proceed, Your Honor. I believe that Miss Owen was trying to reach me last week. I don't know if she still needs to talk to me. And I also wasn't sure if she was requesting adjournment to get an attorney.
Okay. Ms. Owen, are you ready to proceed, or did you need to speak to Ms. Reed first, or what?
I'm ready to proceed.
Okay. That's fine then. Well, we will proceed with the hearing in this matter. Ms. Reed, do you wish to make an opening statement or proceed to your proofs?
A brief opening statement, Your Honor. The parties share two minor children. That's Avery, who's 15, and Evie, who's 9. Judgment of divorce was entered in October of 2018 and awards the parties joint legal custody and joint physical custody with a week-on, week-off parenting time schedule. Since about August of last year, mom has not exercised her full parenting time. With Avery, she's barely exercising any parenting time at all. And then with Evie, it's been kind of sporadic and all over the place. During the summer of last year, she was exercising parenting time in the weekends. And then once school started, it's been kind of messy and unstable for Evie, where she's trying to do week on, week off, but it's really not working due to her work schedule and when the child has to go to school. So we're requesting that physical custody be modified and awarded to my client, as he's been the primary care provider for both children over a year, modified child support and the tax deductions for the children accordingly. Also, last year on May 8th, mom filed a motion requesting a reduction in her parenting time to weekend parenting time, but then failed to appear in an evidentiary hearing in front of the referee, so her motion was dismissed.
I did happen to see that in the file in preparation for this matter. Ms. Owen, you had filed that motion and then didn't appear. Was it your intent to seek a modification and then go to alternating weekends as opposed to the alternating week situation?
So I was having trouble getting my kids to and from school. It was my intent to go to a long weekend with more time in the summer to make up for that missed week time. I filed that motion and I was not able to attend due to work and them not letting me leave without risking to lose my job.
Okay. Well, I guess what I'm asking now is, are you still of that position to modify that or not?
I'm asking for things to say just stay as they are with 50-50.
Okay, that's fine. Ma'am, do you wish to make a opening statement, or you can reserve your opening statement or waive the opening statement?
No, I'll make one.
Okay, go ahead.
So my name is Erin Owen, and I am the mother of Evie and Avery Frazier. Evie is 10 years old and Avery is 15. Today I stand before you to advocate for what is best for Evie and Avery. The law is clear that in matters of custody, the primary concern must always be the well-being and safety of the children. I'm here because I firmly believe that the arrangement Stephen is proposing is not what is best for the children. I firmly believe that they need that deep healthy, meaningful relationship between them and their mother, whom is me. Today, I will present testimony demonstrating my ability to provide what is best for their well-being, including a stable and nurturing environment. Stephen and I did divorce in 2018. Since then, we have shared 50-50 custody. My goal is to not diminish the role of their father, but to ensure that custody arrangement reflects what is truly in the best interest of my children. I trust that this court will carefully consider all aspects of the case, and I'm confident that the evidence will support my request to keep custody as is and show my efforts to foster a positive co-parenting relationship between Stephen and I.
Thank you.
Yeah.
Ms. Reed, you can proceed with your proofs. Call your first witness.
I'd like to call Stephen Frazier.
Okay, Mr. Frazier, have you raise your right hand, be sworn in, then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
I swear.
Okay, go ahead, Ms. Reed.
Mr. Frazier, as we've stated, you guys were divorced in October of 2018. Is that correct?
That's correct.
And prior to you guys being divorced, who was the primary care provider for the children?
Prior to us being divorced, we lived together. We both maintained custody or cared for the children.
Okay. After the divorce, were you guys exercising equal parenting time?
For a few years after the divorce, yeah.
When did that stop?
About 2 years ago.
And 2 years ago, is that 2023 or 2022 for you?
Probably 2023.
When in
Not quite 2
2023
years.
did that stop?
August sometime.
And you know why it stopped?
I believe is because she divorced her most recent husband, Phil, and it was a
And
toxic situation.
when you say she, are you referring to Aaron Owen?
Yes.
So in August of 2023, since we're in 2025 now. Since August of 2023, what has Miss Owen's parenting time been with Avery?
Oh, non-existent.
Can you explain non-existent?
She's probably had him overnight 1 or 2 times since then. She doesn't have any relationship at all with him. It's been just me taking care of Avery. And in the summertime, she tries to take Evie because she has a small apartment. She says she doesn't have room for Avery.
Has she exercised parenting time outside of overnights?
No, maybe once she took him to lunch, I think.
Since August of 2023, what has Miss Owen's parenting time been with Evie?
During the school year, she takes her sometimes throughout the week, depending on her work schedule. But then over summer, holiday breaks, anytime when there's a disruption in the school schedule, Evie's with me overnight to accommodate Aaron's work schedule.
Is she having parenting time every week, or is she trying to do alternating weeks?
Alternating weeks during the school year, but then on the weekend, then on the summer, it was just every weekend or every other weekend.
And that was summer of 2023 and 2024?
Yes.
When she has her during the week on alternating weeks, what times does she have her?
Probably from 5:30 in the evening until she drops her off the next morning for school. Usually, if she doesn't have school, she'll bring her before work.
What time in the morning does she drop her off the following morning?
Usually 7:30.
And what time does Evie start school?
7:40.
Right.
If she has school, her mom will usually take her, or Phil will take her to school. If she doesn't have school, she brings her to me before work.
When would she bring her to you before work?
It depends
What
on when
time?
she has to be to work. Usually 7,
Oh.
6:37.
Who's Phil?
Their ex-stepdad, Phil Owen, her second husband, Aaron was divorced from last August, I believe.
Okay, so Miss Owen's ex-husband is Phil?
Correct.
Is that exchange working?
When she brings her during school hours, or
Yes.
not at all. No, it's chaotic and not consistent, sporadic. There's no set schedule. She uses the kid Aaron uses Evie to text she's here or not. I have no idea when she's going to be here. Sometimes it's within 20 minutes of the set time. Sometimes it's 30 minutes of the set time. There's no consistency at all to it.
What time does Evie have to get up in the morning?
If she has school, she gets up, I think, at 6 at her mom's house. If she doesn't have school, she's still getting up that early if she's at her mom's house because she brings her to me.
Can you describe your relationship with the kids?
Loving, nurturing. They've been with me for quite a while now. Their mom's second divorce was pretty traumatic for them. And they learned to lean on me for their school, their health, their emotional, physical well-being. I lead by example with the children, and I'm there for them consistently.
Okay. How do you show them love and affection?
Either simple routines, the way I wake them up, the way I put them to sleep, the way I make their breakfast, the way I tell them goodbye before I drop them off to school. So, like being consistent and showing them that I notice the little things in life for them, and that I see who they are, and that they're worth my love and time.
What kind of activities do you share with the kids?
Uh, Weekly dinner nights, family movie nights. We go on trips and vacations. Went to Tennessee, to Chicago, go up north camping in the summertime. That's all done by me alone and my wife. We do that together with our children, our joint family. We have wonderful routines and traditions together.
Okay. How do you discipline the kids?
Usually by with limiting their access to their technology and
Okay.
monitoring their time.
Can you describe the kids' routines when they're with you?
Yeah, it's a school every day. We don't miss. And if there's no school, we still have self-care Sundays every week where we take care of our body and our mind to prepare for the following week. We exercise every day. We try to teach them good health hygiene. Uh, don't stay up too late. The importance of getting a good night's sleep. The importance of working hard. The importance of disciplining your thoughts and controlling your emotions.
Can you describe Aaron's relationship with the kids?
With Avery, it's not a relationship at all. And with Evie, I would say probably scary, frightening. Apartment complex where the kid's mom lives is not one of the best. She's told me that there's been incidences of assaults there, and some of the traumatized things Evie's seen mental breakdown wise her mom's gone through. I feel the relationship is traumatized and scary for Aaron and Evie.
Has Miss Owens opened up to you about her mental health struggles?
Yes, in the past over text message, she's reached to me for advice on how to help with her own mental health concerns. Over the years, I've given it to her over and over again because I've worked on my own mental health over the years. And I've tried to give her some of the tips and tricks I've learned to discipline my own thoughts, to discipline my own emotions. But that's kind of fallen on deaf ears over the years. And it seems like every other month there's a mental health episode with her, Theron.
Can you describe the mental health episodes?
Well, I'm not involved with them no more because we limited our communication out to the app, close app. But in the past, they were frantic and hyperventilating and yelling and screaming and not necessarily at me, but at whatever was going on at the moment. Most times it was Phil. She's traumatized. She's screaming and yelling, coming down the stairs. The most recent ones have just been over app close of her reach, saying awful things to me, belittling towards me for no reason.
Has this ever happened at your house in front of the kids?
Oh yeah, last year she was running late to pick Evie up from work, and I had plans to go exercise with our two sons at the gym afterwards, and she showed up at the house honking the horn, screaming at me from the end of the driveway, "Send her out, fat ass, send her out, fat ass." And then she approached the back door. I shut it and locked it, and she started beating on the back door in front of my wife and all our three kids. My current
You
wife and
don't
her
have
three
a
kids were
wife.
there, and
Hold,
she was beating on the
hold on a
window.
second, just a second, sir. Ma'am, don't interrupt, don't interject. You'll have an opportunity to speak and to say your side of it, and you have a chance to question defendant as well, but don't interrupt.
Yes, sir.
Go ahead.
Courtney, I'll call her by her first name, was there with our three children. Aaron and I share. Aaron was beating on the back door, beating on the window, screaming at the top of her lungs to send Evie out, calling me names, acting irate. The police were called because she was sat in the driveway for 45 minutes, and all the kids seen it. Courtney seen it. I seen it. This was happened at my old house last year.
Have there been any other incidents since then?
No, since then she doesn't even pull in the driveway. She parks at the end of the road because she can't control herself. And I'm not sure what I did. I was just had plans to go exercise. Boys.
Okay. Do you have any religious beliefs or practices?
No, I don't.
Do the kids attend any sort of Sunday school or Bible camps?
No, our two oldest boys do go to Catholic school, even though we're not religious at all. It's just a good school for them.
Do you purchase the items that Avery and Evie want and need?
Yes,
Who arranges and takes the kids to doctors and dental appointments?
I do.
Do any of the kids have special needs?
Yes, Avery has autism and ADHD.
Is he seeing a counselor or doctors for that?
He's on a wait list for a therapist at pediatrician's office, and he takes medication when he goes to school every day. And he sees his pediatrician every 3 months.
Okay. Has Miss Owen helped you provide for the children's care?
Not at all. I asked her last summer for help feeding them because I was struggling financially. She told me to apply for food stamps.
Okay. Has she bought them clothes or shoes or anything?
She buys them shoes sometimes, but no clothes. It's all been on me.
Okay. Are the kids seeing any? You had said Avery's on a wait list for a counselor. Is Evie seeing a counselor?
Yeah, she has been for 4 or 5 months now since the incident that happened with her mom. She was on a wait list for about 8 months. So
Is that going well?
yeah, she sees her monthly. I don't involve myself too much in it. I just wait in the waiting room.
Okay. Are you currently working?
Yes, I work as a student employee at Kellogg Community College.
And how long have you been a student employee?
That's 4 months.
Is that per semester?
Correct.
So it goes semester by semester, then you have the summer off?
Yes, there's an opportunity for work studies in the summer, but I'm working on transferring right now.
And how much do you make as a student employee?
So 13.50 an hour, I believe. I only work 10 to 15 hours a week. I usually have to leave at 2 to go pick them up from school, and I get in at 9 because I drop them off after or before in the morning.
And what days do you work?
Tuesdays and Thursdays because I go to in-person school at Western on Mondays and Wednesdays
And what times do you work?
from 9 to 2.
Do you receive any other income?
VA disability.
Are you 100% disabled?
Yes,
And what is that amount?
4,200 a month.
And how long have you been disabled?
That's 2018 is when it was dated from, I believe.
Okay. And do you foresee continuing as a student employee at college?
Yes,
And how long do you foresee being a student employee?
till I graduate.
And when are you set to graduate?
2027.
What degree will you be graduating with?
A bachelor's in cybersecurity.
Are you receiving any other payments from profit sharing pensions or retirement?
No.
Any other military benefits?
On the monthly stipend for going to school. It comes when I'm in registered for class, and it's paid while during active class times.
And how much is that?
It goes based off how many credits I'm enrolled for the semester. This next semester is 1,200. It's based off of three quarters time.
Okay. Any tips, gratuities, or lottery winnings?
No.
Are you receiving any sort of public assistance, like in Medicaid or child care assistance?
No.
Any food stamps?
No.
Do you have any uniform licensing or other costs you must pay to be a student employee?
No.
Who provides health insurance for the kids?
I do.
And how much does that come up?
It's a comprehensive VA program through my disability. I don't pay for it.
Is it TRICARE?
It's the civilian version of TRICARE.
Okay. Any child care expenses?
Avery's tuition. It's $150 a month.
And do you pay that yourself, or does Miss Owen help
It's
you with that?
split. We each pay. That's for 150 for me and 150 for her per month.
And is he in private school?
Yes.
And what status do you claim when you file your taxes?
I haven't filed my taxes in a few years. I haven't had income until this year, so this will be the first time I filed. I'll be filing married jointly.
Okay, and you said that you're married?
I am
Who are you married to?
Courtney Newton,
When were you married?
September 14th, 2024.
How is the kid's relationship with your wife?
Terrific. She's loving and nurturing, protective.
And how long did you know your wife before you got married?
2 years.
And do you live in a house or apartment?
A house.
And how long have you lived there?
We just bought it. We moved here 2 months ago.
And before you moved into this current house, where did you live?
I rented a house,
And how
Battle
long did
Creek,
you live in that house?
for 3 years.
Okay. How many bedrooms is in the house that you currently live in?
5,
And how many bathrooms?
3.
Does each of the kids have their own room?
Yes, they all have their own rooms.
Can you describe your housekeeping standards?
High and frequent, daily
No.
cleaning, daily laundry, daily dishes done.
Who lives with you?
Me, my wife, Courtney, Jaden, my oldest son, we share with Aaron Owen. He's 18. Avery, who's 15, lives with me full time. Evie, most of the time, and my wife's 3 children, Layla, Brennan, and Dawson, are every other week.
Okay.
So how many,
And
how
how's
many
the
does that make? How many kids then?
It's 6 kids altogether. Well, one's 18, so 5 under age 18 and
Okay.
under kids.
Thanks.
Yes, sir.
and your wife's kids are every other week?
That's correct.
And what are the sleeping arrangements like when your wife's kids are there?
They sleep in their own room throughout the school week, and then usually on a weeknight there's a game room, a family room, an extra living room type thing where sometimes we'll sleep there together on a weekend night, but during the school week they sleep in their own room.
Do the kids have any chores or responsibilities?
Yes, they're responsible to take care of their placement after they've eaten at the table, push their chairs in. They're responsible for putting their shoes away when they come home from school, taking their backpacks to their room, brushing their teeth on a daily basis, clean their rooms, put their laundry in their laundry hampers. Our standards are high and we maintain it daily.
Okay, and you said, how's the relationship with Avery and Evie and your wife kids?
Oh, it's good. My wife has a daughter who's 13 and Evie's 10, and they have a great relationship with one another. Their rooms are right next to each other. They even share a tunnel where they can crawl through to each other's rooms. Yeah. Evie's relied on Layla, I think, for a lot of emotional support over the last 6, 8 months or so. And Avery's 15 and my wife's sons are 13, 12 and 10, 9, excuse me. And so he doesn't really see them all that often because he's 15. He goes to his own room and kind of just hangs out by himself. But they have good relationships. We go on family trips together, like once a month usually. We have dinners together once a week usually. So
Okay. Do you have concerns regarding Miss Owen's home?
I do.
And what are those concerns?
The location, safety, some of the things she's told me over text messages about some of the assaults that's happened there. It's some of the drug paraphernalia on the ground sometimes when you go there.
Okay. Based on your testimony, it sounds like the kids are kind of being split up with Avery being primarily with you and mom not exercising parenting time, and then Evie kind of going back and forth all over the place. Do you believe that's in their best interest?
Not at all. Evie's never been an only child. She's had her two brothers, Jaden and Avery, her whole life until 2 years ago. And now she's supposed to go be the oldest child at her mom's apartment and care for her little sister when her mom goes to bed earlier. Can't do it mentally.
Do you believe it's best to keep the kids together?
I believe it's best they stay together. They've always been together. They've always had each other. It's never just been Evie by herself away from her brothers. She's always had her brothers to be there to support her, to rely on.
Okay. Do you use any drugs?
No.
Are you prescribed any prescription medications?
For blood pressure,
Do you use any marijuana or marijuana products?
I do.
Is that around the kids?
No, never.
Oh. How often do you use marijuana products?
A couple of times a week.
Do you consume alcohol?
I do.
Is that around the kids?
No, never. So after 9 o'clock,
And how often do you consume alcohol?
a few times a week.
Have you ever been ordered to participate in a substance abuse treatment program?
No,
Do you know if Miss Owen uses drugs?
I'm not sure.
Do you know if she uses marijuana or marijuana products?
I'm not sure.
Okay. Have you ever been convicted of a misdemeanor?
Yes, I believe PBO violation,
And when was that?
2018.
Is that PPO still in effect?
No,
Okay. Have you ever been convicted of a felony?
no,
Have you ever been the subject of a child protective services investigation?
no,
Okay. Any physical issues that affect your ability to be a parent to the kids?
no.
Do you know if Miss Owen has any physical issues that affect your ability to parent the kids?
Yes, she does.
What
Her
are her
Addison's
issues?
disease, I believe it's called, where she has bouts of uh, low muscle tone, poor muscle weakness, where she's not able to participate in activities. She has to go to bed and lay down early. Things that prevent her from caring for the children because she's physically incapacitated because of her illness or her mental illness, or both combined.
Has she reached out to you when she's not able to take care of the kids?
No,
Has she reached out to you to explain her difficulties with Addison's disease?
yes.
When was the last time she did that?
When we had the hearing with the referee, she talked about her. She asked me questions if I was aware of her inability to. I can't remember the exact question she asked, but it was if I'm aware that she has disabilities and she can't care for the children.
And that was last year?
Yes.
Do you have any mental health issues that would affect your ability to parent the kids?
No.
Are you taking any medications for your mental health?
No.
Are you currently seeing any counselors or therapists?
No.
What school does Avery attend?
St. Phil Catholic High School, Battle Creek.
And how is he doing there?
He's coming along. This is his first semester. He passed all his classes last semester, so it's good news
Does
for him.
he have an IEP or any special classes?
It's a private school. They don't participate in those, but he does have a school social worker that we work with directly to help him with things like organization, staying on task. I'm really involved with Dave's school, and they're small, so the ability for me to be directly involved with each teacher is I receive daily emails about his participation in the class and the homework for the day.
And you participate in parent-teacher conferences?
I do.
Do you know if Ms. Owen participates in parent-teacher conferences?
She has not the past few years.
Okay. Is tuition currently paid up for Avery?
On my side, yes.
Do you know if Ms. Owens paid her half of the tuition?
Not for this year, no. It's around $1,200, $1,600 behind.
Is Avery at risk of being expelled because of the tuition's not being paid?
No.
Are they working with you on a payment plan?
Well, she's on her half of is on a payment plan monthly that she doesn't pay until she files taxes. So
Okay.
I'm not sure if they would expel them for non-payment. It usually gets paid once a year by her. I pay monthly as per the payment arrangement that we set up
Okay.
every year.
And what school does Evie attend?
Lakeview Middle School.
And how is she doing in school?
Bit of a change. She's going to fifth grade now, so it's from elementary to middle school. And last year was hard for her because of the divorce between her mom and Phil. Some of the struggles she had in fourth grade carried over into fifth grade, but I think she's doing well. She's got a good group of friends, and she sees a counselor once a month. She has a good relationship with her stepsister, my wife. She has just people to reach out to.
Okay. And does Ms. Owen attend parent-teacher conferences with Evie school?
No, she hasn't the past few years.
Any extracurricular activities that the kiddos participate in?
Evie participates in volleyball. Avery's working on his eligibility, maintaining his grades to be able to participate in track next year. St. Phil has higher standards for eligibility because he can't fail any classes to participate in them. That's one thing he wants to do next year is participate in track.
Okay. And what is your involvement in the volleyball?
She just started. She's tried soccer and dance in the past. This is something new she wants to try. So she's registered for Wallace Park and starts in January, I believe this month.
Okay. Can you describe your communications with Miss Owen when I ask that? Are you guys able to co-parent well, or are there communication issues?
No, we don't co-parent well at all. It's toxic, like it's never been before the past 2 years.
Can you explain what you mean by toxic?
I feel that she's constantly looking to blame me for just being the children's dad and being in their lives and participating in activities that I should participate in because she can't be there because of her work schedule. She lashes out at me, belittles me, tries to control every situation that I'm in with the kids as for no reason, just to make my life more difficult, I think.
Okay. What is your proposed visitation schedule?
Every other weekend, and then I believe one day throughout the week for Evie and
Okay.
Avery.
And would you want that year round, or would you want it different in the summer?
Yes, year round. To maintain some consistency because right now there's no consistency, no predictability of the schedule. Avery never even sees his mom.
And do you believe that mom wanting to exercise parenting time with Evie and then not exercising any parenting time with Avery is having a negative impact on Avery?
Oh yeah, he sees the favoritism every day. He never goes on trips with his mom. She takes Evie took trips all the time every weekend, which she has her, but never involves Avery. I think he feels left out. He feels discarded, kind of abandoned. The way she moved out of her old house she shared with Phil, she packed up Evie stuff, Holland stuff, and left our Jade and Avery stuff at the old house. I'm the one who went to the old house and packed up our boys' stuff and brought it to my old house. She just abandoned them, it felt like.
And who's Holland?
That's her daughter, who's 5, I believe, she had with Phil.
Okay. So she has not taken Avery on any trips during the weekend?
No, never.
Are you willing to facilitate a relationship between mom and the kids?
Yes.
Do you believe she's willing to do the same for you?
No.
Does mom use the kids to communicate with you?
Yes.
Do you believe that's appropriate?
Not at all. I've asked her on several times to stop telling the kids when she's going to be here to tell me so I can have them ready, not just be surprised that they showed up or the kids come downstairs and put their shoes on. It's not how it's supposed to be.
Is the app close app working for both of you?
No. It's
Why don't you believe it's working?
I believe it was just a way for her to control the situation. The reason we was ordered to use app close in the beginning was, I believe, for the wrong reasons. She lashes out at me at app close, cusses at me at app close. It's not even about the kids or about their schedule or about the routine or about how they're doing or their well-being. It's about me and what I'm doing or what I'm not doing.
So she doesn't send you text messages at all that she's going to be there in 15 minutes with the kids for school?
No, not at all. Maybe once I've ever got one of those.
Has there been any instances of domestic violence between you and Miss Owen?
No.
How far apart do you guys live?
10, 15 minutes.
I'm just looking at my notes real quick. Has Miss Owen ever threatened or detained the children from you?
No.
Has she ever denied you parenting time?
No.
Have you ever denied Miss Owen parenting time?
Yes, on the incident that occurred when she showed up at my house beating on the door. Evie did not want to go to her then.
Has there been any other instances since then?
No.
Any other parenting time denials since then?
No.
Was a parenting time complaint filed for that denial of parenting time?
Yeah, she used it in the previous motion with the referee.
Okay, but that was dismissed when she did not appear?
Yes.
Okay. I have no further questions.
Hey, sir, before I turn it over to the plaintiff, just clarify, I might have missed it. When did that situation occur where she was beating on the door and the windows?
Around May 8th, I believe, of 2024.
Okay. Thank you. Ms. Owen, if you have any cross-examination of the defendant, you can proceed at this time.
All right, I would like to call Stephen.
He's already sworn in. You can just question him.
All right. So you want full custody of Evie and Avery, is that correct?
Yes.
Stephen.
Sir, did you hear the question?
Yes, I do.
Okay, then why didn't you answer?
I'm sorry. I said yes, Your Honor.
Oh, okay, well, we didn't hear the answer. Go ahead.
Are you aware that on May 8th, I asked to lessen my parenting time in order to be able to provide transportation to school for them?
Yes, I'm aware.
Is it true that you denied that request?
Yes, I denied it
Why?
because they need their mom.
So after that, I filed for child support so I could get a kingdom builders to pick up the kids and pay them to take them to school and pick them up. I filed for child support, and straight away you asked for full custody, correct?
You filed for child support for saying you were taking the children 182 and a half days of the year, and you were not. You haven't taken Avery a day overnight over a year now. One time.
Okay, did you answer the question? I filed for child support, and straight away you asked for full custody. Is that correct?
Yes,
Why?
because I've had full custody of them for years. You just want the money. They've
Are you
lived with me
aware
for
that you
years.
have? Are you aware that you have that you and I have a parenting plan in place?
Yes, I'm aware.
That parenting plan was meant to outline how we would share important events in Evie's and Avery's lives, like school activities. Isn't that right?
Yes,
You agreed to attend school events with me when possible as co-parents, correct?
yes,
So in Evie's first year of middle school, there was an open house event, right?
yes,
And you were present at that open house event?
yes.
Did you inform me beforehand that you planned to attend the open house with me? Without me?
I'm not sure if I remember correctly. It was a public event. You were invited as well. It showed up when I had time with my
So
schedule.
you brought your girlfriend with you to the open house, is that correct?
To the open house, yes.
How do you think Evie felt?
Objection, speculation.
Okay, ma'am, what's your response to the objection?
I'll move on.
Okay, thank you.
So you're aware that bringing your girlfriend to the event, despite our co-parenting arrangement, you
Evie
violated our
requested it.
parenting plan, right?
Evie requested it.
So are you aware that bringing your girlfriend to the event, despite our co-parenting arrangement, violated our co-parenting plan, aren't you?
No, it didn't.
That's not correct.
Ma'am, you can ask questions, you don't comment on what his testimony is.
Okay. Okay, so given that you chose to bring your girlfriend instead of adhering to the co-parenting arrangement, doesn't that suggest you may not be fully committed to the parenting plan or to a cooperative co-parenting relationship with me?
I'm going to object. My client already answered the question that he did not violate the co-parenting plan, and I also don't see how this is relevant.
Okay. Ma'am, how is it relevant?
It is relevant because Stephen has many times, and I have evidence of him excluding me from conferences, from special events,
Okay, well,
from
maybe you need to examine each of those particular instances, and then we'll determine if it's relevant.
okay. So Stephen, I requested from you half of the cost of Evie's camp supplies. Is that correct?
Yes.
Can you describe why or what the process is that you thought that you would deny that request?
I paid for half of everything already.
Did you deny Evie's camp supplies request over the app Close app?
Yes.
Do you stand by the decision to deny that request, even if it means that Evie might have missed out on an opportunity?
You're requesting I pay half of the stuff you picked out and bought. I paid for half of everything she needs already, not half of your Target shopping trip.
I included a receipt with the things that were on her list for her camp supplies. Did you get that receipt?
Yes.
Would you say that your communication with me is generally respectful?
Yes.
Have there been any instances where you've spoken to me in a manner that you would describe as disrespectful?
No.
Do you believe that disrespectful communication is justified when you're frustrated?
No.
Do you recognize how disrespectful communication with me can affect and has affected our ability to co-parent effectively?
I don't disrespectful communicate to you.
Are you aware that I have the entire transcript of App Close?
So do I.
Are you aware?
Yes.
Are you aware that it shows your disrespectful communication?
No.
Can you confirm that you've scheduled medical appointments for the children without informing me?
No, it's put on the joint calendar we shared before.
We shared before.
We still share calendars. It's on the app close calendar. I maintain all the child's appointments. You're informed.
When you scheduled the appointment, did you make any attempt to discuss it with the other parent beforehand?
What appointment are you referring to?
Dental appointments, medical appointments, child visits,
I've texted you their height and weight on
therapy.
their child visits. I text you when Evie has oral surgery you never showed up to. I text you about Avery when he goes to the doctor. I text you about all their appointments. I inform you.
Have you considered how excluding me from medical appointments might affect the relationship between them and I?
No, you excluded yourself.
Do you acknowledge that both parents have a right and responsibility to be involved in important decisions regarding their health?
Yes.
Can you confirm how many school days Evie has missed this year?
5. We took a trip to Tennessee. She missed 4.
Did you know that consistent attendance is crucial for your child's academic progress?
That's why I make sure she's there every day. This was a planned family vacation.
Going forward, are you committed to taking steps to improve your child's attendance?
I make steps every day.
It's been more than 4 days. She's only missed school with you.
You're only talking about Evie. We have 2 kids together that are minors. Avery as well. He missed 4 days for Tennessee trip as well.
I take Avery to school every day, every week I have him.
Just for the school year you have. Don't forget about last year. You didn't do not one day.
Would you agree that the children tend to pick up on the way their parents interact and that you can affect their emotional well-being?
Yes.
Are you aware that it's important to share critical information about your child's driving habits, especially if there's a concern about their safety?
Avery doesn't drive.
Your Honor, I don't know how to ask the rest of my question. I don't want to do it wrong.
Well, that's up to you, ma'am. It's, you can ask whatever questions you want. There'll be an objection if it's not proper.
Would you agree? Oh,
Do
sorry.
you have any more questions? Mr. Owen, do you have any more questions?
No, sir.
Okay. Ms. Reed, any redirect?
No, Your Honor.
Okay. Okay. Next witness, Miss Reed.
Would like to call Miss Owen.
Okay, Miss Owen, if you would raise your right hand, we'll have you sworn in and then we'll proceed.
Do you solemnly swear or affirm the testimony you are about to give shall be the whole truth and nothing but the truth?
Yes.
Okay, go ahead.
Miss Owen, do you live in a house or an apartment?
Apartment.
And how many bedrooms is that apartment?
It is 2 bedrooms.
And how long have you lived there?
1 year and 4 months.
And who lives with you?
Myself and my daughter, Holland Owen, and Evie lives with me week on and week off consistently over the school year. Avery prefers not to come. He is on the autism spectrum and he does not like change or change of structure or any of that.
Where do you currently work?
I work at CareLink Medical Supply.
How long have you worked there?
Just over a year.
And what days do you work?
Monday through Friday, 7:30 to 5 o'clock.
And what is your rate of pay?
$17 an hour.
How many hours a week? Is that 40 hours a week?
Yes, 40 hours.
Do you get any overtime?
Once in a while, it's not consistent.
Over the last year, how much overtime did you receive?
When I first started, I received about maybe 5 hours a pay period, but now they have cut down on overtime and it's no longer available.
Before CareLink, where did you work?
Oak Lawn Hospital,
And how long did you work there?
1 year.
And what was your rate of pay at Oaklawn?
$17 an hour.
And what do you do at CareLink?
At CareLink, I do respiratory therapy.
Okay. Do you have any payments from profit sharing pensions or retirement accounts?
No,
Do you receive any military benefits?
no,
Any disability benefits?
no,
Any tips, gratuities, or lottery winnings?
no.
Do you receive any public benefits like Medicare, Medicaid, or food stamps?
I receive Medicaid and food stamps.
Is that for you and Holland, or is that for you and Avery and Evie?
That is for me, Holland, and Evie.
Do you have any uniform licensing or other costs you have to pay as a condition of your employment?
I do have to maintain my vehicle in a specific way in order for myself to drive to in-home visits with patients. But I'm not sure if that answers your question.
But there's nothing specific that your employer requires, like for you to buy specific uniforms from them?
Oh, yes, I have to buy specific uniforms. I have to hold specific auto insurance on my car. And I have to have a license, a respiratory therapy license once a year. It's about $125 this year.
Do you know how much your uniform costs are?
Let's see. I would say a uniform is $80 and I have about 4. That'll last probably a good year.
Do you provide any additional insurance for the children?
Medicaid, I do not provide commercial. It's not affordable for me.
But Evie is the only child on Medicaid, correct?
Evie's on Medicaid, Avery is on Medicaid, and now Jaden is on, I believe, is on his own, since he turned 18.
Do you have any childcare expenses?
I do, but it's not consistent. Did
Is that for Evie or is that for Holland?
Your Honor,
Yes.
I'm seeing, I'm sorry, I don't know her name. I'm seeing her rolling her eyes at me often, and it's
Well,
really concerning to me.
not gonna control her responses, ma'am, just answer the questions. Go ahead, Miss Reed.
The question was if Miss Owen has childcare expenses.
Yeah, let me get my expense.
Ma'am, I think she asked if those were with regard to Evie or your other child.
Evie and Avery?
Yes.
Yes. I do have some expenses with Avery Avery. With Evie, when it comes to before school care from last year.
Well,
Do you have current childcare expenses?
Those last year expenses are current because they were not paid by myself or by Stephen.
Going forward, are you going to have childcare expenses?
Not at this time.
And what status do you claim when you file taxes?
I'm sorry, could you repeat that?
What status do you claim when you file taxes?
Single head of household.
So you agree that you have not exercised parenting time with Avery over the last year and a half?
I do not agree.
When have you exercised parenting time with Avery?
On the weeks that are my weeks that he would like to come with me. I give him the choice very much.
When was the last time you had parenting time with Avery?
Over Christmas.
Before Christmas, when was the last time you had parenting time with Avery?
It was probably at least 3 weeks to a month. I do take Avery to school every day on my weeks because I can do that with my schedule for work, so I do try to do that. So even though he's not with me, I do go to Stephen's house, pick him up, take him to school.
When you had parenting time with him, how long was it?
Just a couple hours. He likes to be in his own space, and he does ask me if it's all right if he goes back to his bedroom.
If you work from 7:30 till 5, when would you propose the children go to doctor and dental appointments and counseling appointments so you could attend?
I had asked Stephen if he could make the appointment as early as possible or as late as possible so I can ask for the time off at the end of my workday or the beginning of my workday. When I did do that, Stephen stated that it was up to him to set those times, and it wasn't I didn't have nothing to do with it. And I do have an exhibit of that.
But you had previously stated that you could not take time off for the referee hearing last year, or else you would be at risk of losing your job. But now you're saying you can take time off to attend a dental appointment doctor appointment, or counseling?
That's correct. It depends on the day and it depends on what's happening. If I have patients, if I have respiratory distress patients, if I have PTO available, if Stephen works with me and schedules those appointments where I can attend and far enough in advance where I can ask for the time off.
Do you have access to the children's calendars for school?
Yes, I do.
Do you have access for the events like volleyball for Evie?
No, I do not. I was not informed of volleyball. That's new. Evie would have told me. Stephen did not tell me.
Have you claimed the kids for taxes since 2018 going forward?
I have claimed the kids for taxes since 2018. Going forward in our parenting plan, we do every other year. I'm sorry, it was every other year, one parent had two kids, one parent had one kid. But now that we have only two minor children, we would each have one child moving forward to claim.
You were claiming Avery even though Avery wasn't living with you?
Avery was. It was about 6 to 9 months where Avery had stopped coming with me during that divorce. Avery had not lived with Stephen the entire time. It was only a period of about 6 to 9 months.
Is Phil still helping transport the kids to and from school?
Yes.
And how often does he do that?
About maybe two times a week.
And that's on your weeks?
Yes.
Have you tried to apply for a 3-bedroom apartment?
I did, yes.
And when was the last time you applied?
I'm looking right now. I'm on 3 waiting lists. And it's just a really long wait. I moved out of my marital home, escaping a bad relationship. It was a fast move. I didn't have a choice.
No further questions.
Any additional witnesses, Ms. Reed?
No, Your Honor.
You rest your case?
Yes.
Okay. Ms. Owens, now you have opportunity to present your case. Do you have any witnesses that you'd like to call, or would you like to testify on direct? You've testified on cross, but it's up to you on whether to give any direct testimony.
I would like to give a direct testimony.
Okay, go ahead.
All right. So Stephen and I, we began our relationship at the age of 15.
Ma'am, I'm not gonna rehash all of this. We'll go from the date of the last order or the judgment in this particular matter, which was back in 2018 forward.
Okay. I was going to say that so this is still 2018. We were married in 2009. Come 2018, Stephen's anger issues increased, and substance abuse became an issue. We went on to have more children. We had Evie and Avery. We were divorced in 2018. I was threatened with violence while working for Penfield Schools during that time. At that time, the school was put on lockdown and Stephen was detained and jailed for some time. I was gained a PPO against him for a year. When Stephen was served with divorce papers, he left for a period of 6 to 9 months without any word. During that time, I began a relationship and remarried, and I had a daughter with my then husband, Philip Owen. Recently, I was granted full physical and legal custody of my daughter, Holland, from that marriage. So Evie and Avery will share a sister who lives here with me 365 nights a year. Stephen and I had a wonderful co-parenting relationship for about 6 years straight. We did birthdays, holidays, even school events together. We even comfortably took vacations as one with or without our new spouses or partners. There was a year during Christmas where Stephen was not able to provide what he wanted, and I helped by buying him a load of gifts to give the kids from him. Another example is when something would need replaced on my vehicle, Stephen was always there to fix it, make sure that the kids had a safe car to ride in. Nobody could understand how we put our differences aside after a messy divorce and learned to parent together so well. In 2023, I served my most recent husband with divorce papers. It was emotionally abusive, high conflict marriage, and I thought it was better for the kids to stay with Stephen in order to protect the kids during the transition. Stephen and I agreed that he should keep the kids, and we should keep them away from the divorce. So they stayed with Stephen throughout the proceedings. I then moved out of my marital home into the only place I could afford and find, which was here at Bentrey Apartments, 2-bedroom apartment. There's been one incident here of violence. There's been some paraphernalia on the ground, but other than that, I feel safe here. About a year ago, Stephen introduced his girlfriend. From that time on, Stephen started to become verbally abusive and manipulative to me. He quit discussing the kids with me. I tried multiple times to plan our oldest son, Jaden's high school graduation. He wouldn't allow me to help. I wasn't able to attend my oldest child's graduation open house because Stephen wouldn't allow me to. My oldest child, and missing one of his most important milestones of his life. In May of 24, I went to pick up Evie from Stephen's home after work. Stephen stated that I was late and that is why he withheld Evie. I wasn't late, as he says, as I was in a hurry to get to my youngest daughter's t-ball game. The game started at 6, so I was between 5:30 and 6 o'clock at Stephen's home. I normally arrive to get Evie from Stephen at 5:30. When I went to the door, through the window, I could see Evie trying to walk out of the door, and then I could see a woman that grabbed her pretty forcefully around the neck from behind. So I knocked on the window, hoping to get her just to stop. Evie looked very uncomfortable. I went to the open door, and Stephen shut the storm door hard on my hand and arms, leaving bruises. I called the police, hoping to get Evie back for my parenting week, and Stephen kept her from me for over 3 weeks. I had to file a motion in order to get her back. On August 13th, another high conflict example of Stephen's co-parenting. In the message, I was trying to schedule time to go to Avery's open house, and he refused to work with me. I could have went after work, but Stephen purposely makes it so I can't go. On August 19th, Evie had meet the teacher night. I was able to get off work with time to take her. The event was 4 to 7. Stephen stated he couldn't make it at 5:30 when I was able to attend, and he would have to go at 4. I mentioned the divorce decree. This states that boyfriends and girlfriends should not attend these private, non-public educational meetings or activities unless we agree 48 hours in advance. Stephen stated that she'll be going with me. File whatever you want. In October, we were awarded the opportunity to use AppClose for our communication. Since then, there's been a lot less problems between Stephen and I. Stephen has used the app to show significant high conflict behavior, which is all documented. He is unable to co-parent successfully with me, as it shows in the documentation. And he has been showing signs of alienation towards me many times, also in the documentation. I wasn't notified on Avery's appointment, well-child appointment, December 11th. Stephen brought his girlfriend and scheduled during a time that I am working. He does this on purpose. I have multiple examples, multiple exhibits. I received a letter from Evie's school stating that Evie has been missing too many days. Evie has not missed one single day while she was with me. Her absences are with her dad. Also exhibit. Evie is happy. She's showing stability in her environment and my ability to meet her needs, including physical, emotional, and discipline. She recently did a student self-reflection at school. She rated herself all fives, 5 being high. Evie and I have a bond, including emotional ties between us. She shows physically, emotional, and verbally her desire to have plenty of time with me. On September 28th, I expressed to Stephen that he was making appointments at times that I cannot get away from work. He states that appointments are to be scheduled only when he is available. Right, that's all, Your Honor.
Okay. Ms. Reed, any recross?
Just looking at my notes briefly, Your Honor. I have no recross.
Okay. Ms. Owen, any additional witnesses?
No, sir.
Okay. Any other evidence you wish to present?
No.
Okay. Well, do you rest, ma'am? Meaning you conclude your case?
I'm sorry, are you talking to me?
Yes.
Yeah, that concludes my case.
Okay. Thank you. Any rebuttal, Ms. Reed?
Briefly, Your Honor, I'd like to recall Stephen.
Okay. Go ahead. Still under oath, sir.
Mr. Frazier, Miss Owens has alleged that she had substance abuse issues. Is that true?
No, not at all.
And she says you were emotionally abusive during the divorce. Is that true?
No, not at all.
She's also alleged that you won't allow her to attend Avery or your oldest child's graduation. Was that true?
No, not the reason she wasn't allowed at my house is because she was banging on the window. That's why I told her not to come to my open house at Jade. But the other stuff is public events. She can come when she wants. It's a block of time. It's not me setting the schedule. Open houses are open house. It's from a block of time to a block of time. I go when I had free time.
So you're not preventing her from attending doctor's appointments or parent-teacher conferences or open houses at school?
Not at all. And I inform her about all these things in app close, and she's been notified about volleyball. I sent you that in app close as well. I tell her about the appointments. I tell her about everything to do with the kids. I'm not trying to alienate her, not no way. She's alienated herself.
Okay. I have no further questions.
Okay. Ms. Owen, do you have any cross-examination?
No, Your Honor.
Okay. Okay, thank you. Then anything else, Ms. Reed?
No, Your Honor.
That concludes the case in this matter. Then we'll go to Ms. Reed, closing argument.
Your Honor, we believe that there's been proper cause and change in circumstance pursuant to the Von Marcus standard, and it is in the best interest of the children under the best interest factors to modify physical custody in this case and award that to my client, as he's been the consistent provider for the children for over a year now. Been primary in his care. Ms. Owen admitted in her testimony that during her contested divorce proceedings, the children primarily lived with my client. During the summer last year, they primarily lived with my client. And it appears from the testimony only from the beginning of school and around August of this last year, or for the last couple of months, has she attempted to exercise week on, week off, but that's only with Evie. And that's causing conflict between the siblings. It's not in the best interest of the children to split the siblings. And it's also causing issues with exchanges and pickup and drop offs as she's not communicating. Now, Miss Owen alleges parental alienation, but she has full access to the schedules, parent-teacher conferences. My client has provided her all the information regarding the children. And while, yes, everybody works, she testified that she can be at those appointments if she has the time to take off. My client's providing her those dates and times so she can take that time off. It's not alienation if she's not actively participating in that as her choice. It's not alienating her or damaging her relationship with Avery when she's not exercising parenting time with Avery. My client did file a motion to change the custody to reflect what the parties had been doing for over a year now, briefly after he received the child support motion, as that child support motion requested and had a calculation page attached to it for 182.5 overnights, which Ms. Owen isn't exercising. So we're requesting that he be awarded sole physical custody, Ms. Owen be granted parenting time and alternating weekends to make it consistent and to prevent the chaos that's happening with Evie on alternating weeks with school and exchanges. There is a right of first refusal in the judgment of divorce for childcare. And I know how this court feels about rights of first refusal for childcare. I think that this order to do alternating weekends year round would prevent some of the issues that the parties are running into. And so we're requesting that that schedule be implemented, child support be modified accordingly, and the provision of the judgment of divorce regarding tax deductions be awarded to my client.
Okay, thank you. Ms. Owen, closing argument.
Yeah. Well, thank you for the opportunity to speak today. I just want to emphasize that my primary goal here is to continue to ensure the continued stability and well-being of the children. The current 50-50 custody arrangement has allowed them to benefit from the love and guidance and support of both of us. That has worked well for us for over 6 years. The only time it took a hit was when I went through a very bad divorce. That is over now, and things are moving forward and up. Unfortunately, the evidence has also shown patterns of high conflict behavior and alienation from Stephen. These actions jeopardize not only our co-parenting relationship, but also my children's sense of security and their right to have a loving relationship with me and their dad. While I cannot control Stephen's behaviors or his answers today that were incorrect and not true, I have taken every step to avoid conflict. I've tried to shield my kids from unnecessary stress and focus on creating a stable, loving environment for them here at my house. I ask that we preserve the current 50-50 custody arrangement, which has proven to work in the past, and it was always the best interest of the kids. This arrangement allows them to maintain strong bonds with both of us, and it honors their fundamental rights. And that is all.
Okay, thank you. Anything else, Ms. Reed?
No, Your Honor.
Okay, thank you. Well, in this matter, as in every case, credibility is an issue in the consideration for the court. And oftentimes parties will allege that the other party or their witnesses is not truthful or have been lying. Obviously, that's occurred in this case as the plaintiff states the defendant has not been truthful. Court has found, however, that inconsistencies in testimony does not mean that an individual has lied. Conflicting testimony can occur as a result of the witness's background, perception, bias, understanding, misunderstanding, or simply by mistake. When inconsistencies occur, the court attempts to determine if they can be reconciled by other testimony or evidence. There has been some conflicting testimony in this case, which be to the extent typically that the court would normally see, but the court will consider that as we proceed and go further. In these particular cases, the court's always required to notify the parties pursuant to MCL 722.26A, parens 1, whether a joint custody is appropriate. In this case, the parties do have a joint custody provision under the judgment of divorce dated October 8, 2018, granting the parties joint legal and joint physical custody. The question always is whether the parties are able to cooperate and generally agree concerning important decisions affecting the welfare of the children. If the parties cannot agree to essential decisions, then the court has to consider sole custody in a particular case. In this matter, again, I'm not going to comment on all of the testimony that was rendered in this case, or we would spend the additional amount of hours that we've already spent going through all of that. And the court, however, is pursuant to MCL 722.21 at SEC required to go through a best interest analysis, which the court will do. In this case, though, the first thing that the court has to do is to determine if there's an established custodial environment in this case. An established custodial environment provides that the court must look to and determine whether over an appreciable period of time the children naturally look to the custodian in that environment for guidance, discipline, necessities of life, and parental comfort. The statute provides that the age of the child, the physical environment, and the inclination of the custodian and the child as to the permanency of the relationship shall be considered. The mere fact that the children are one primary residence in and of itself is insufficient to establish a custodial environment. And this is important because if there is an established custodial environment, then the court cannot change that unless there's produced clear and convincing evidence that it is in the best interest of the children. Clear and convincing evidence is evidence which produces in the mind of the trier of fact a firm belief or conviction as to the truth of the allegations sought to be established. Evidence so clear, direct, weighty, and convincing as to enable the fact finder to come to a clear conviction without hesitancy of the truth of the precise facts and issue. In this case, clearly, the parties had prior to 2018, had an established custodial environment. And that's why they ended up into a joint custody arrangement. That apparently did persist for a period of time, and up until approximately sometime in 2023, I think there's been discussion about, I think it was August of 2023 when things changed. The plaintiff had testified that she was going through a difficult divorce, and that in fact she had asked and actually had filed a petition to have the children go live full-time with the defendant. And however, that wasn't taken care of because she didn't appear at the hearing, and therefore that got dropped. And notwithstanding that, the court will still note that she did file a petition at that time stating it was in the best interest of the children that they be solely in the care and custody of the defendant. So the court is taking that into consideration. When we look at what has happened in this case since then, as I go through the factors, we will address all of that. In this case, so the court will note that at least since August of 2023, so about a year and a half, the children have been to various degrees, although Evie has spent considerable time with the plaintiff, that she's been spending, it appears, the majority of the time with the defendant since that particular time, that she has court will note in looking at the factors in this case that does appear that she has had a loving, nurturing relationship with in the defendant's home, that she has again assimilated in that home well, as again, notwithstanding the time that she was with the plaintiff. It's disputed. The parties didn't address anything other than, well, that she had been with the plaintiff for a period of time, and then wasn't during the school year, but it was during the summer when they had alternating weeks. But the plaintiff has disputed that in this case. I guess probably address Avery first. That's the easiest in this matter. That the defendant has testified that, again, that the plaintiff and Avery do not have a relationship, that in fact Avery will go and see the plaintiff sporadically, and she even acknowledges that it's sporadic, acknowledges that in fact with regard to Avery, that that oftentimes when he goes with her, that he only spend hour and a half to 2 hours, and then he wants to go back to the defendant's home. She says it has to do with somewhat of the autism that he has, and that he has the surroundings at his dad's. He's comfortable with that. He's familiar with that. But notwithstanding that, it does appear that, again, looking at the factors for an established custodial environment as to whether the child, in this case, looks to the custodian in that environment, guidance, discipline, necessities of life, and parental comfort. As it relates to Avery, the court will find that obviously it's clear from the evidence that by the testimony of both parties that Avery does look to his father for that. And so the court will find that as it relates to Avery, that there is in fact an established custodial environment with the defendant father. As to Avy, that is a little bit different and more difficult assessment in this case, because the plaintiff has taken more time with her than obviously than with Avery. But the court is troubled, and I'll address that when we go through the factors about the division of the children and the impact that that can have on the child in this matter. Clearly, it is a disruption to Evie to be separated from her brother, and be separated. Apparently, that the parties have an adult son who resides with the defendant who is in that home, and that Evie, with not going to that home, not residing in the home, that's somewhat severed the relationship with the adult son as well. And so the court is taking that into some consideration in this particular matter when it relates to, again, the environment as to whether it provides guidance, discipline, necessity of life, and parental comfort. Court will note it does appear in this matter that Evie has, since that August 2023, has spent the majority of the time with the defendant, that in fact, looking at providing necessity of life, that he's the one that's provided for the medical, that he is again provided for the doctors, dental appointments, things of that nature, that he's the one that's went to the conferences, and the plaintiff, through her testimony, acknowledges that. She claims it's because he's scheduled various things when she's not available, but it does appear that her schedule, she's works from 7:30 a.m. to 5 o'clock p.m. And obviously, to get appointments with any care providers outside of that time frame was almost impossible. So it does appear that he's been providing for those necessities of life, that he has been providing for the discipline. He stated that what he does relates to discipline is to take away the technology, those types of things, that he has provided her with the guidance in this particular matter. So the court will note that it does appear, although it is much weaker than with Avery, that Evie does look to him for a majority of the, again, the guidance, discipline, necessity of life, and parental comfort. Although I would state that the testimony as it relates to parental comfort and really the guidance has been limited in this particular matter, but the court will find that that does slightly favor the defendant father in this matter. So what happens, the court, noting that, cannot change the established custodial environment unless presented with clear and convincing evidence. In this matter, the court will go through the factors. First factor, under the best interest of the child test, is the love, affection, and emotional ties existing between the parties involved and the children. In this case, it does appear that the love, affection, and other emotional ties existing between, again, Avery and his father are more substantial and more significant than that of that with the plaintiff. As to Avie, the court will find that there is love, affection, other emotional ties existing between she and the plaintiff, as the court notes that also between she and the defendant. Next factor is the capacity and disposition of the parties involved to give the children love, affection, guidance, and continuation in the education, raising the children in a particular religion or creed. There's been no testimony about any particular religion or creed other than with Avery that he does attend St. Philip School, which is a Catholic school. The court would note that the defendant was responsible for getting him into that school. Court will note as well that, again, as it relates to capacity and disposition, court will note that each party has the capacity to provide the children with love, guidance, and affection and the continuation of education, but it does appear that the defendant has been providing a more substantial amount of that, in that he has been one responsible for the education, that at least it's as to Avery, court would note that it does not appear that the plaintiff has that disposition to provide that. She hasn't in the last year and a half, and that has, again, caused a strain in that particular relationship. So the court will find that this factor does favor the defendant father as to both of the children. Next factor is the capacity and disposition of the parties involved to provide the children with food, clothing, medical care, and other remedial care recognized or permitted under the laws in place of medical care and other material needs. It does appear that, again, that the parties both have the capacity. The court will note that the defendant had testified about his son disability, that he does make in this matter, that he has disability income of approximately, well, $4,200 per month. He also has a school stipend when he's in school of $1,200 per month, as long as he's in school. And court will note as well that he also testified that he works as a student employee at KCC, where he makes $13.50 an hour at 15 hours per week. And so it does appear that he has the capacity to provide that. Court will note that the plaintiff had testified that she makes $17 per hour at through her employer, and therefore she does have the ability and the capacity to provide for the material needs in this case. It does appear that weighing this, that again, that it has been the defendant, at least the last year and a half, that has paid the majority of these expenses, and that it's kind of fallen on him in this particular case as it relates to the children, providing him with those material needs, as well as the medical care, which he has been solely responsible for. Court will find that this factor does slightly favor the defendant father. Next factor is the length of time the children have lived in a stable, satisfactory environment and the desirability of maintaining continuity. As I had alluded to previously, again, the time when the plaintiff was going through the divorce, she even acknowledged through her pleadings and testimony today that it was less than stable, satisfactory environment, and that is why she filed the petition to have the children stay with the defendant. Since that time, there's not been really any testimony that the defendant's home is not a stable, satisfactory environment, that again, he has been providing that the children apparently do well in his home, that again, they've been solely with him for at least that, well, for Avery, he's been solely with him for the last year and a half. Evie, a majority of the time during that particular time. And in fact, in that household, they have, again, other children of the now current wife, as well as the one adult child that I'd referenced previously. Court will note that the defendant's home does appear to be more stable, and the court will award and determine that that factor weighs slightly in his favor. Next factor is the permanency of the family unit, the exist or proposed custodial home or homes. In this case, there's been no testimony that, at least currently, that there's not any permanency to the family unit in the plaintiff's home. She's been divorced since sometime in 2023, whether it occurred right then or after, but she has been divorced since. There are some issues in this matter, that the defendant has remarried in August of 2024, and there's been no testimony about any lack of permanency in that home. Court will find that this factor weighs in favor of both equally as to both parties. Next factor is the moral fitness of the parties involved. There's been very little testimony, if any, about a lack of moral fitness. Although the plaintiff had testified that that there was, as she claims, some sort of abuse by the parties were together, but that has not been anything since, again, since the 2018 when they divorced, and quite frankly, they worked very well together after that, as she acknowledges. Court will find that this factor does not weigh in favor of either of the parties in this case. Next is the mental and physical health of the parties. There's been allegations of mental health issues on behalf of the plaintiff. There's not been any testimony about mental or physical health of the defendant other than his testimony that he's fine, that there are no mental or physical health issues. And even though there's been the allegations, the court has not seen any independent evidence to establish that. The court will find that this factor weighs equally as to both parties. Next factor is the homeschool and community record of the children. In this case, obviously, the homeschool and community record of Avery is clear that it is with the defendant, as he's not really had much of a homeschool or community record of all. It was the home of the plaintiff. As it relates to Evie, the court will note that, again, not a lot of testimony as to the home record, but there has been some as it relates to the plaintiff's home with Evie. And however, as it relates to the school record, the court will note that she has provided transportation her weeks to get Evie and Avery as well to school, that she has not attended conferences. And she claims it's because it was set up for them to attend that together, that they couldn't because the defendant stated it didn't work into his schedule, that he had to go earlier for some reason, and that as a result, he testified that she has not attended those particular school conferences. Likewise, testified that she didn't attend the adult son's graduation. He said that she could have attended the graduation, notwithstanding the fact that she couldn't attend the open house at his home. And the court notes that that could have, in fact, occurred. There's not been any testimony really about community record of either of the children in this case. So the court will find that this is very slight, but a very slight advantage to the defendant in this matter. Next factor is the reasonable preference of the children. If the court considers the children to be a sufficient age to express a preference. I did have an opportunity to interview the children today. They were very pleasant, and did have an opportunity to have conversation with them. And I am taking into account and consideration the preference that they expressed. Next factor is the willingness and ability of each of the parents to facilitate and encourage a close and continued parent-child relationship between the child and the other parent. Court notes that the plaintiff testified that back in May of 2024 that the defendant did detain Evie, but that was just for a couple of weeks, and then she was able to get Evie back. And so the court notes that the parties had testified, both parts, that they've been able to resolve things. They've been able to facilitate the relationships, that they had very close and ability to do that. So the court's not going to weigh this factor in favor of either of the parties. Next factor is domestic violence, regardless of whether the violence was directed against or witnessed by the children. Again, there's been very little testimony about this. That would only pertain to what happened prior to the entry of the judgment of divorce, although the plaintiff did testify that the defendant has not been the most, I guess, hospitable, if you would, or most easy to deal with. And in fact, the communications on up close. But notwithstanding that, the court notes that that often occurs, and it doesn't appear to be substantial in this case. And likewise, there's no evidence other than her brief testimony about that. So the court will not consider that factor. Next, any other factors considered by the court to be relevant as to the particular child's dispute. The court does determine there is some other factors that are relevant in this case. The court notes that relevant to this matter always is the fact that if the court were going to, I guess, do as the plaintiff has requested, that would require that Evie and Avery would be separated from each other. And the court always looks at that breakdown of that relationship between the siblings if they are to be separated. And court finds that that is obviously not desirable, unless the only time I found it to be at all desirable is when you have maybe children that are openly hostile to each other and simply don't get along, and that's the best way to have it work, is that they do not have a relationship where they are in the same household together, etc. But in this case, the court will note that there has been some obviously difficulty and would be difficulty if the children are separated, so I am taking that into consideration. When I do consider all of that, and again, note as well, the other factor is that, as mentioned by the defendant, is that Avery sees the favoritism towards Evie, that is in fact damaging to him, and that when the plaintiff left with the children, or with Evie, that she took all of her stuff, left all of Avery's stuff with the defendant, that she is not engaged with Avery. She's not taken him on the same trips, provided the same things that she does to Evie, that court finds that to be damaging and potentially substantially damaging to Avery. When I look through the factors under the Child Custody Act, the court does not weigh them like you would a baseball box score and say, okay, you've come up with X amount, you've had, of the 12 factors, you've won on 7, the others won on 5. Excuse me. Rarely does that happen in any event, but court would note that the Court of Appeals in the Dembski case has stated a child custody determination is more difficult and subtle than an arithmetic computation of factors. It is one of the most demanding undertakings of a trial judge, one of which he must not only listen to what is said to him and observe all that happens before him, but a task of requiring him to discern and feel the climate and chemistry of the relationship between the children and the parents. This is an inquiry in which the court hopes to hear not only the words, but the music of the various relationships. In this case, the court will note that that is accurate, and that the court does not always have an opportunity to, again, make such a narrow and limited determination in these cases, that I have to look beyond the testimony, beyond the evidence presented, in determining whether it is in the best interest of the minor children. When I do this in this particular case, obviously the court, I'll address as it relates to Avery as I've had to under the factors. In this court's mind, it is clear and convincing that it is in Avery's best interest to be solely in the physical care and custody of the defendant, so the court will so order that. The court does believe that the parties had an opportunity to communicate, to do that as it relates to important decisions in the children's lives. And in this case, the court does believe that the parties are able to come to decisions of importance in the children's lives as it relates to legal custody. Doesn't mean that the parties always agree, but means that they can generally come to an agreement. The court does not see that that is not appropriate in this case. The court will continue joint legal custody, which requires the parties to communicate on concerning important decisions in the children's lives. So the court will continue that. But as it relates to Avery, the court will find by clear and convincing evidence that it's in his best interest that he remains solely in the physical care and custody of the defendant father. As to Evie, again, looking up the factors, again, there's different testimony, substantially different testimony than Avery, but in some instances not that much difference as it relates to the other factors. When I take all the factors together in this matter, the court does believe that the court can come to a clear conviction without hesitancy of the truth of the facts and issue, and the court does believe that it is in the best interest of Evie that she be placed in the care and custody of the defendant father. So the court is going to award to him physical custody of both of the children in this matter. And the court will note, for purposes of calculation of support, that Ms. Reed, you can calculate that using his disability income of $4,200 per month, as well as his monthly school stipend of $1,200 per month, and his 15 hours at $13.50 per hour as a student employee, and calculate on that, and calculate the plaintiff's support obligation at $17 per hour for a full 40 hours per week. Court then has to look at, beyond that, has to look at factors concerning parenting time, and court notes that parenting time is provided under MCL 722.27A, and the factors under number of cases in this matter. But again, those factors are first special circumstances and needs of the children. In this case, the only special needs would be as it relates to Avery with the autism, and the court notes that that has been provided for by the parties. They've recognized that, and therefore they have taken that into consideration as to his parenting time. Second factor is whether a child's less than 1 is not applicable. Next factor, likelihood of abuse or neglect of a child. There's been no allegations or evidence of abuse or neglect of the children. Next factor, likelihood of abuse or neglect of a parent during the exercise of parenting time. The court will note the plaintiff has brought that up as it relates to the treatment by the defendant. The court does not find that that raises to the level of abuse. So the court will not consider that. Next is the inconvenience or burdensome impact of travel. It's been testified that the parties only reside 10 to 15 minutes apart, so there's no inconvenience or burdensome impact of travel. Next is whether the parent is reasonably expected to exercise their ordered parenting time. The court will find that, again, the plaintiff has abdicated that for 1.5 years as it relates to Avery. She is taking it more consistent as it relates to Evie, but that she has, again, not taken all of it in this case. Next is whether a parent whether a parent frequently failed to exercise parenting time. That would go hand in hand with the last factor, and the court's already tested or commented on that. Next is the threatened or actual detention of the child. There's been the allegation back in May of 2024 that the defendant detained Evie for a little bit of time, but that was really only for a couple of weeks. The court not look at that as being substantial. As it relates then to any other factors in this case, court notes that, again, there's not been really much as it relates to other factors in this particular matter. But the court will note that, again, what the court will do in this case is grant, as it relates to the children, knowing that, again, she hasn't exercised the parenting time. This is a little bit difficult with Avery. Court will give her the opportunity to exercise that and provide that to her on a alternating weekend basis, Friday at 6 o'clock p.m. to Sunday at 6 o'clock p.m., alternating holidays, as well as the court will continue that through the summer, as she has not exercised any extended, but the court would give her the opportunity to exercise 2 weeks of extended parenting time during the summer with Avery if she wishes to do so for trips, travel, vacation, etc. As it relates to Evie, that's a little bit different, is that she has had her in her care more. So what the court will do in this matter is the court is going to grant to her parenting time from 6 o'clock p.m. on Friday through time school starts on Monday morning. And the court will also allow her to exercise one overnight per week on Wednesdays if we can't agree, from after school or from 4 o'clock p.m. until the following day when Evie would go back to school, that she can have that particular time. The court will grant her, as it relates to Evie, the alternating holidays as well, and the alternating weeks during the summer. With that, court will ask Ms. Reed, is there anything, Ms. Reed, that you believe that the court has not addressed or that I need to address before we conclude?
Is my client able to claim the kids for taxes?
Well, he has custody, and under the IRS code, it provides that the parent with custody has the right to claim the minor children for tax purposes. So because he's granted physical custody, he would have the opportunity to claim the taxes, claim them on taxes pursuant to the IRS code.
I just asked because it's in the judgment of divorce, and sometimes we run into issues with the IRS when they do an audit and a party provides a judgment of divorce. You're going to follow what the judgment says.
That's fine. You can
So we
include
can
that, include that in the order. Anything else, Ms. Reed?
Are the parties going to continue using app close?
Yes, I want the parties to continue to use app close. I would state in this case that there's been plaintiff has stated that defendant is not using app close. Defendant has stated that he is. All I can say is continue to use it. Notify the other parent when there's appointments, conferences, things of that nature. As sir, as you stated, you're already doing that, so just continue to do it. If you end up not doing it, she has a right to bring the matter back before the court to enforce that, but the court would order that they continue to do that so that they're apprised. The court would already notify Ms. Owen pursuant to statute. In this particular case, you have the opportunity to be provided with communication as it relates to all issues concerning medical as well as schooling under MCL 722.30 to be apprised of all of that. And you have a right to acquire all that information from those various authorities as it relates to the children. So you have that ability if that's not being provided to you. The court would note that the parties had previously had a right of first refusal. Obviously, that's an issue of contention at times. And again, the court doesn't believe that that's really something that would, again, assist the parties in their relationship as they go forward. So the court is going to delete the right of first refusal when it was entered back in 2018. The kids were much younger. They're getting older now. They're going to have more and more activities, events, things of that nature, and that makes it much more difficult to facilitate that than when children are younger. So the court would remove that as well. Ms. Reed, put that in the order. Ms. Owen, go ahead, Ms. Reed.
For the 2 weeks for Avery, I know it's going to be hard for Avery for summer. Can we do like a notice for that by April 1st if mom wants to take those or try and take those?
Let's do it by May 1st of each year, that she'll notify the defendant what the weeks are that she wants to take them. Ms. Owen, is there anything else you believe the court has not addressed or needs to address before we conclude?
No, I wasn't really listened to, so it's cool. I'm good.
Okay.
I conclude.
Okay, thank you.
Have a great day.
That will conclude this matter, and Ms. Reed, you can submit that under a 7-day, and court will wish you both the best of luck. I hope everything works out.
That case showed how excuses and finger-pointing crumble under scrutiny. The mother's claims of alienation couldn't outweigh her history of favoritism and missed responsibilities. The court thankfully sided with stability, but it raises important questions. Will this ruling push her to repair the damage and repair her relationships with both children? Or is it just another chapter in a pattern of neglect and missed opportunities? Let me know your thoughts in the comments. And don't forget to like, subscribe, and hit that notification bell for more gripping courtroom moments. Thank you for watching. See you in the next one.